Welcome to Lecture 4 in this series on critical reflections on the EU's data protection regime. Chapter 3, written by Dr. Róisín Costello and myself, Dr. Mark Leiser, examines consent as both a legal mechanism and a normative claim. Consent can provide a legal and lawful basis for processing, but its deeper purpose lies in protecting control and individual autonomy. The chapter asks whether digital markets allow that promise to survive. It then tests the consent model against two practices that stretch conventional assumptions: the scraping of publicly accessible data for generative AI and the use of deceptive design to steer users towards behavioral advertising. The governing question is not simply whether someone clicked, it's whether the surrounding conditions made that click meaningful. The GDPR did not invent consent. The Data Protection Directive already required consent to be freely given, specific, and informed. The regulation strengthened and systemized that architecture through Articles 411, 6, 7, and 9, and together with recitals 32, 42, and 43. Article 411 requires a freely given, specific, informed, and unambiguous indication of wishes through a statement or clear affirmative action. Article 7 places the burden on the controller to demonstrate consent and protects withdrawal. Consent, therefore, operates within a market-oriented fundamental rights framework. It permits processing that would otherwise lack a lawful basis, but only where the controller creates conditions in which the data subject can make an intelligible and voluntary choice. The EDPB links valid consent to control, genuine choice, and the ability to refuse without detriment. The chapter places that position within control-based privacy theory. Weston, Freed, and others connect privacy to the capacity to decide what information to disclose, to whom, and within which relationships. A Rasian account of autonomy adds a crucial condition. Autonomy requires an adequate range of morally acceptable options and freedom from manipulation, coercion, and excessive influence. Choosing between bad options does not necessarily amount to self-government. Consent, therefore, succeeds only when it communicates more than acquiescence. It must reflect deliberative action by a person who can realistically say so. The distinction between thick and thin consent makes the problem concrete. Thick consent allows the individual to shape the relationship. It assumes voluntariness, understanding, meaningful alternatives, and enough bargaining space for refusal to matter. Thin consent preserves the legal form while losing much of that substance. The user clicks, the controller records the event, and the interface moves on. But structural power, limited capacity, or decision fatigue may have narrowed the choice in advance. This distinction also explains consent's moral significance. Valid consent can transform conduct that would otherwise be impermissible. When consent becomes thin, that transformative force weakens, even if the organization can still produce a record of the click. Digital markets often undermine the assumptions required for thick consent. A small number of dominant providers may offer similar terms. Lock-ins and limited interoperability make switching costly. Dense and repeated notices produce fatigue rather than understanding. Refusing a major service may also carry social or cultural costs that the formal language of opt-out ignores. The result is a market in which the existence of a nominal alternative does not prove meaningful choice. The chapter does not argue that every online consent is invalid. It argues that validity requires contextual scrutiny of the options, the power relationship, and the practical consequences of refusal. Autonomy cannot be inferred from interface completion alone. Generative AI supplies the first technology-led stress test. Large models depend on extensive datasets, often assembled through web scraping. Public accessibility does not itself amount to consent for every latter use. Article 9, subsection 2, subsection E may remove the special prohibition where the data subject has manifestly made special category data public, but it does not provide a complete legal basis for aggregation, analysis, or model training. Articles 5 and 6 still govern, and Article 7 remain relevant where the controller relies on consent. Purpose limitation, fairness, and transparency therefore retain independent force. The chapter's central warning is contextual. Information disclosed in one setting does not automatically become permission for processing at a different scale and for an unrelated purpose. The chapter identifies several possible safeguards: clearer transparency about collection and training purposes, strict purpose control, data minimization, anonymization where it generally removes identifiability, and accessible opt-out mechanisms. Yet those measures do not make the consent problem disappear. Individual consent at the scale of internet scraping may prove practically unavailable, while broad statements about model improvement may not satisfy specificity or reasonable expectations. The regulatory task therefore extends beyond asking for another click. Supervisory authorities must clarify lawful basis, fairness, and accountability, and they must evaluate the real-world effects of training practices. The example exposes a wider weakness in notice and consent. The model works best for discrete transactions, not diffuse reuse across time, context, and technical systems. The second stress test concerns deceptive design. Cookie banners in consent interfaces can privilege accept all, conceal rejection, bundle unrelated purposes, pre-select options, obstruct withdrawal, or repeatedly nag the user until resistance gives way. The chapter places these practices on a visibility spectrum. Some manipulation appears directly in color, size, and placement. Other influence sits deeper in the architecture that sequences choices and withholds information. These designs exploit bounded rationality, inertia, and decision fatigue. They do more than reduce usability. They impair the conditions that make consent freely given, specific, and informed. Children and other users with reduced capacity face particular risk. A decision taken to escape friction does not necessarily express a genuine preference. The practical response begins with symmetry and revocability. Accept, reject, and customize options should receive equivalent presentation. The interface should require active selection rather than pre-selection, state purposes in clear language, disclose relevant third parties, and make withdrawal as easy as agreement. Controllers should preserve records of the information and choice architecture presented at the time of consent and audit those practices as law and technology change. Yet the chapter's conclusion reaches further. Consent should not bear the entire burden of protecting privacy. Fairness, transparency, purpose limitation, accountability, enforceable design duties, and active supervisory oversight must operate alongside it. The legitimacy of consent is contextual, not binary. The chapter's core takeaway is that consent protects autonomy only when the surrounding market, interface, and data practice make refusal meaningful. The GDPR supplies demanding legal criteria, but those criteria cannot neutralize structural power by themselves. Do not forget to check out the next video in this series where LexZard examines surveillance advertising, Meta's changing legal basis strategies, consent or pay, and the limits of consent as the device for legitimizing systemic monitoring.